Good morning, ladies and gentlemen. My name is Tony Payan. I'm the director of the Mexico Center here at the Baker Institute. Thank you for being here. For over 2 years now, Mexico has been engaged in a sustained effort to pass and implement very significant reforms to its energy sector. As you well know, these reforms constitute an important shift in Mexico's energy policy, which had remained largely unchanged for over 70 years. This transformation is even more noteworthy because the country remains a key player in the world's energy markets, and given these structural reforms, it is now poised to become even more deeply integrated in North America. Of course, Mexico faces a difficult moment internationally. The price of oil remains low, and the energy investment expectations into the country have had to be adjusted accordingly. Many of the capital investment flows the country had foreseen will now have to wait for better times. Yet, the Mexican government will be pressed to deliver the dividends of energy reform sooner than the current global conditions may allow it. This is one of the greatest challenges of the Peña administration. But the greatest challenges to the reform may perhaps not come from without, but from within. The energy reform must work for the people of Mexico above all if it is to succeed in the long term. That means that its implementation has to consider important political, economic, social, environmental, and cultural challenges. To examine these international and domestic issues surrounding Mexico's energy reform, several of us, including myself and Erica de la Garza from the Latin America Initiative, traveled to Mexico City in July 2014. There, we met with several key Mexican thinkers outside and inside academia to engage in a reflection on the obstacles to reform. We then created a consortium that consists of the University of Houston's Center for U.S. and Mexican Law, the Tecnológico de Monterrey, the Universidad Autónoma de Nuevo León, the Center for Development Research, CIDAC, and the Mexico Center here at the Baker Institute. Together, we identified key issues, international and domestic, worth exploring that you are about to listen to today. What you're about to listen to today are the reflections coming from over 1 year of research on these challenges. I hope that the collective knowledge that we have accumulated during the course of this project will be useful to you, but above all, to policymakers who will have to resolve these challenges to ensure that the reform render full fruit. Let me welcome you to the Baker Institute, and thank you for accompanying us today. Now, let me invite Steven Zamora, he's here he is, my colleague and friend, to say a few words about the project before we begin our first panel. Steven.
Good morning, everyone. This is the Good Morning America Tony and Steve edition. And I must say, Tony and Lisa Guaqueta, I love this room. I love this institution. Do they actually have to pay you to work here? I have heard some of the most outstanding presentations that I have attended for many years in this room. This is a tremendous, the Baker Institute is a tremendous contribution to Houston and the world. And it's a pleasure for me, as director of the Center for U.S. and Mexican Law at the University of Houston, to collaborate with the Baker Institute. We hope to do so for a long time, until we get all these little problems of the rule of law solved. I would like to also thank our co-sponsoring institutions, and it's wonderful to see them here. I love collaboration. I'm an integrationist. I believe in the integration of the United States, Mexico, and Canada, and beyond. I think that makes us stronger. It'll be bumpy. It's always bumpy. But, you know, integrating Texas and Louisiana isn't so easy sometimes. So it's a good plan. I would like to help introduce the subject of our symposium today with some personal reflections that I think are relevant to our discussion. 40 years ago, as a young lawyer in Washington, D.C., I left the law firm I was working with to accept a job in the legal department of the World Bank. I was excited about this opportunity because I had gone to law school wanting to work in the area of economic development and in dealing with relations between the United States and developing countries. I went to law school straight out of the Peace Corps. I was chatting with Carlos Galvez, I think, this morning about how I learned to speak Spanish, or Castellano, as they say, in Colombia, in the Peace Corps. And then I went to law school, economic development. After I went to the World Bank, it didn't take me long to realize that lawyers were not at the center of the World Bank's decision-making process. The legal department counted many outstanding lawyers from around the world, but with some exceptions, most of our work consisted of drafting loan agreements with the bank's developing country borrowers, agreements that, due to the peculiar nature of the bank's lending practices, would never face the harsh light of litigation. One exception of this was my boss, Aaron Brockus, who was the general counsel of the World Bank at the time. And he created this funny little institution that people used to laugh about called the International Center for the Settlement of Investment Disputes. Are you kidding me, Ronnie? You know, who's going to be interested in that? Much has happened since then. At that time, the World Bank was managed by economists. It probably still is. Project directors and managers would decide the conditions of lending and would hand the package to the lawyers and say, put this in legal language. So I left the bank in 1978, and I entered academic life at the University of Houston, teaching international commercial and business law. And I also started to direct a summer legal studies program in Mexico City, in fact. And over the years, I embarked on a lifelong study of Mexican law and a lifelong love of Mexico. In 1982, Mexico's default on loans from foreign creditors created a wonderful laboratory of teaching for me. Mexico was the first country to declare its default, and it ushered in what we sometimes refer to as the lost decade of the 1980s, forcing many countries, including Mexico, to restructure their foreign loans and take belt-tightening measures. A major consequence of the external debt crisis was that the IMF and the international development banks, including the World Bank, embraced the Washington Consensus pushed by the Reagan administration, a prescription for economic growth that included policies promoting free markets, open trade and investment policies, and the privatization of government-owned monopolies. The IMF and the development banks, including the World Bank, began to condition their lending on the restructuring of countries' economies to embrace wholeheartedly the mantra of free markets. I remember inviting an Argentine lawyer to my class once in Houston, I think this in the late 1980s, and he said, you know, in Argentina, we believe in free markets. We're like the convert to a faith that embraces the faith more fervently than the people who were part of the faith before. Well, the restructuring proved to be a bumpy process, to say the least. Project directors at the World Bank discovered that if you require governments to adopt laws to privatize state-owned companies and to promote free markets and open competition, the desired changes did not take place smoothly. Economists are valuable designers of economic change, but the persons who implement those changes on the ground level are often lawyers. The so-called restructured economies lacked the legal institutions necessary to implement the restructuring. They lacked efficient and impartial judicial systems, well-designed competition enforcement agencies, and other legal entities that we sometimes take for granted. In the late 1980s, the World Bank recognized that lawyers might have something to say about how economic models work on the ground level, and the bank decided to create a small legal modernization unit. I don't know if it still exists. I was invited back to the World Bank at that time to attend a small meeting of Mexican experts. You know what it takes to be a Mexican expert? To have a little bit more expertise than the person on the street, which in the United States means you don't need a huge amount of expertise. But I was invited back to this meeting to discuss how the World Bank could help promote judicial reforms without violating the bank's charter, which prohibits the bank's engagement in, quote, politics. Good luck with that, right? I'm not aware that the bank ever undertook any concerted effort to promote judicial reform in Mexico through its lending processes. My sense is that the World Bank and other agencies like it discovered fairly quickly that economic changes presuppose societal changes. And the efficient legal systems that such change requires are not built overnight. Guess what? Legal systems do not consist solely of laws. If they were, Mexico would have the most efficient legal system in the world because the Mexican Congress is a world champion in adopting legal and constitutional reforms. But rather, legal systems consist of legal institutions, which are complex agencies. And the main ingredient of efficient legal institutions is not the set of rules that define it, but rather the practice of individuals that make up the institution. And the individuals themselves operate according to practices that reflect the legal culture, an unwritten set of principles drawn from national history, personal experience, community practices, etc., etc. The studies that make up the Rule of Law project that you will hear about today, and we don't have all of our presenters. The number of studies commissioned, some of the speakers were not able to attend today. But they engage in varying degrees the problem of legal institution building. It takes many years and considerable investment to create fair and efficient legal systems. The passage of adequate laws is just the starting point. In my opinion, Mexico is not making the investment necessary to bring about the legal institutional change that is needed. I'm not saying that there are not efforts being made, but there's insufficient investment. For example, judicial reform is taking place and is essential to fulfilling the goal of adherence to the rule of law. Oral proceedings. In 2008, the Constitution was changed requiring oral proceedings throughout the country to be implemented by the year 2016. It is now the year 2016. We will see how well those changes occur. I've talked to some criminal lawyers, for instance, and litigators in Mexico say, oh, oral proceedings, we've always had oral proceedings. That's not true. This is a new kind of oral proceeding. So there are big changes to be made. I look forward very much to hearing the comments of the really outstanding people that we have asked to provide these reports, which will eventually be published. You'll be happy to hear. You'll be able to buy it at your local supermarket, and I hope you do. It'll be published in both Spanish and English. Again, Tony Payan and Baker Institute, thank you for the collaboration, and we will continue now with the substantive discussion.
Well, it's my fault for forgetting my glasses in my office, so I can't see what's in front of me. But let me introduce to you somebody who really needs very little introduction for our opening. A man who wrote the prologue to this hopefully book, as Stephen was mentioning, and a man who has been dedicated to the study of Mexico, who has been really a bridge between the two countries, and who has been very concerned with the research on development, and founder of the of SIDAC, one of our partners in this project. Luis Rubio. Luis will offer us a reflection on the rule of law in Mexico, which I think will be an excellent framework, a kind of a frame to this picture that we're going to try to convey to you today. Luis, thank you. Thank you for joining us.
Good morning. Thank you, Tony. Good morning to all of you. Given Mexico's history in the economy and in energy, no sector or issue is more transcendent than energy, and that is why the reforms that were undertaken in 2013 are so important. The question now is how to manage such a complex field with few rules, little experience of the enormous complexity in terms of the actual issues of the industry, the politics around it, and as Steve Zamora was mentioning a couple of minutes ago, the enormity of the legal challenge involves implementing this is not an issue of engineers or economists. It has to do a lot with rules of the game, with contracts, with settling disputes, and that entails a complexity that is largely alien to Mexicans. I am I'm not a lawyer, but have been very concerned about the issue of the rule of law for a long time. The issue that underlines and that lies beneath the questions that the project that Tony and Steve Zamora have brought together is precisely the rule of law. In energy in Mexico, the rule of law didn't seem that important because we had a monopoly, or a couple of monopolies, a utility company and Pemex. And even though, of course, there were legal issues, they didn't amount to more than contracts. Today, the legal questions and the legal framework becomes paramount. So the rule of law is a topic over whose meaning there is no consensus, but about which the issues that are relevant are pretty clear and pretty obvious. The project that will eventually, I hope, becomes a book was written mostly by lawyers on a topic that is critical to Mexico, because the rule of law is indeed a catchphrase, but it constitutes, it entails a big conception of the relationships among parties in a transaction. But there are enormous differences in the way developed and developing countries regard the law. So it is easy to assume that one's view is universal. Lawyers tend to give one meaning, for instance, while economists have developed a far more reaching definition or definitions of what the rule of law entails. Most important, while lawyers tend to see the normative side of the world, other social scientists tend to see incentives and disincentives in rules and procedures. And the question is how to bring these two together. The one dimension of the differences in conception of the law in the US and in Mexico is quite telling. The concept of the law itself is understood differently, and the ways and criteria under which decisions are made bear no resemblance to similar considerations in the US. The way decisions are made vis-a-vis the rule of law and adherence to the law are clearly distinct in both countries. And in the case of energy in particular, which is the issue of the day, the legal issues are most relevant. Energy has long been a critical and highly political sector in Mexico's economy. It has been under strict governmental management since 1938, when the expropriation of oil took place. And as a result, the sector is less developed than in countries with similar income levels. All of this changed when the law was changed, first in 2013, the constitutional amendment, and then implementing legislation in 2014. Enabling legislation overhauled the energy sector and allowed private and foreign investment in it. And this opened up a multitude of opportunities and mechanisms for private parties to invest, participate in, and run independent energy operations in the country. The reforms redefined Mexico's prevailing culture and legal norms. And this demands a radically new setup because political rather than legal criteria has ruled over energy and to a large extent over Mexico in general. The law and the Constitution could be considered more a series of aspirations than of strictly adhered to rules. Once investments begin to materialize, new issues will become paramount. New questions will arise, and these will present a different set of questions for lawyers and for government officials to deal with. And in this vein, the weakness of Mexico's judicial system, Steve referred to the reforms of implementing an oral system of criminal system. This system is certainly not going to be ready by 2016, by the middle of the year when it's supposed to. It also entails a dramatic shift in the way lawyers think, in the way the judicial system operates, in the way politicians work. It may transform and bring about fantastic goodies for Mexicans in terms of the settling of disputes, but it's not going to be, it constitutes a radical departure from where we stand. And in this, again, the weakness of Mexico's judicial system underlines the inability of the state itself to both adhere to the law and compel others to do so. At the heart of this lies an issue of question of power. If somebody can decide and impose a solution, a decision, regardless of checks and balances, regardless of other instances in society and the legal framework, then Mexico has serious problems. And this is not going to be easy in the energy sector. Nonetheless, Mexican political leaders have long understood the implications, at least in the abstract, of the absence of checks and balances, of the absence of the rule of law, and the need that foreign investors in particular have to understand clear and recognized rules and recourses in case of disputes. The question is how to deal with this. If one looks back, NAFTA was to a large extent a way to borrow institutions from the US to deal with disputes in the context of trade and investment, investment outside the energy field. So there's no dearth of experience and at least comprehension of the need to deal with the legal questions posed by energy. Again, NAFTA has been the most important framework for investment and trade for the last 25 years or 20 odd years. NAFTA provides a clear path for this, and it has shown that Mexicans can adhere to rules just like anyone else can. As a result, my sense is that energy is not going to be outside the realm of the possible. So, on the broader questions, on the broader issues, the principle behind the rule of law is pretty clear, and it is that governmental authority is legitimately exercised only in accordance with rules that are written, publicly disclosed, and enforced through well-known pre-established procedures. If one accepts this definition, which, again, in the case of NAFTA, Mexico has adhered to systematically and comprehensively, then energy has a framework set up for itself. The real question in Mexico is going to be broader, how to implement that for society at large, for the country at large, aside from the questions dealing with bilateral relations or trilateral relations. So asserting the rule of law implies a commitment to a distinct social, political, and legal order. And this entails a disposition to accept the law as the norm and the mechanism of interaction among people, organizations, and government on all matters. There's a saying in Mexico that there's no issue or problem that does not merit a constitutional amendment. There was, for Americans, used to no more than 26 amendments, and in fact 24 if one excludes one that kills the other, and 10 that were introduced the first day. Then Mexicans had, in one single day in December of 2013, 50 amendments, just to give you a sense of how different things are. That was one single day. So the real question is how things can change on the ground. I have no question about the ability of Mexico to deal with the energy, the legal issues on energy on a bilateral with foreign investors because NAFTA sets up the rules and the structure. The real questions are how to deal with those on the ground for Mexicans and for the daily livelihood of Mexicans in general. Thank you very much.
We have a few minutes. We have a few minutes for Q&A. So if you have any questions, there it is. If you have any questions, please. We have a microphone here, and I think we have a microphone on the other side as well. I have a question, Luis. I'll take the floor for a second while people kind of clear out their thoughts on what you said. So NAFTA was a way in which Mexico essentially bound itself to rules that were, as you mentioned, predictable and enforceable on trade and investment. And it was a way of importing that kind of rule of law certainty. And energy will probably be like that if Mexico certainly wants to attract the investment that it expects and then play with the big boys in the energy markets. But you also said we need to get it to the rest of society. We know that there's a lot going on in Mexico: journalism, civil society, daily justice, the implementation of daily rules and basic human rights. Who and how is that going to happen? How is Mexico going to bind itself to that added extra steps to finally achieve the rule of law as you define it?
Well, Tony, that's the world of fantasy. The reason why there is no rule of law is that there's enough power to impose decisions and actions by authorities. So at the end of the day, what Mexico would require is the introduction of checks and balances that force those in power to respond to be accountable to society, to other powers, and that's a conundrum. There is no easy solution. It could be if one looks at the international arena, it could be the result of a crisis. It could be the result of enlightened leadership, and it could be the result of a society that grows strong enough to demand and require the government or the powers that be to deliver. I hope it's not a result of a crisis, and I hope it's a result of an interaction of society and leadership, but it's not obvious that it will materialize. If one looks at the past, some of the most significant advancements in this matter have taken place as a result of mostly leadership, but the pressure of society has been building, has been growing, not always enlightened pressure. NGOs don't necessarily have the right solutions, even though they have often the power to force politicians to react to it. But you're raising the key question, and for which there is no obvious and absolute response or solution.
Diana Negroponte from the Woodrow Wilson Institute. Luis, thank you for your very profound analysis, and for Steve, too, for this conference today. Luis, presumption of innocence is, for me, the hardest part for Mexicans to understand. And it was introduced as a key concept in the reforms at exactly the same time as the president announced war on drugs. So presumption of innocence and war on drugs, to me, are incompatible. How have the reforms proceeded struggling against this contradiction?
Two answers. It's not by coincidence that when the presumption of innocence was built into the reform of 2006, that the movie came out and the title of which was Presumption of Guilt. So Mexicans were already laughing at the very question. Calderón never put forth and never used the expression war on drugs. His pretense was to impose the rule of law on or the rule of government, or to pacify the country, he ended up producing the opposite result. But my point is not to argue for or against Calderon. My point is that I don't think there's a contradiction. I think that it was a very bad policy, like many other bad policies in Mexico and in the world, or a bad strategy rather, that was meant to pacify and ended up producing an enormous unsavory result. For many decades, Mexicans had de facto accepted criminal organizations running on their own without any limit or any governmental intervention, often governmental figures benefiting from it, till it became simply impossible to tolerate. And the reason it became impossible to tolerate, and that brings me back to the question with Tony, is an issue of power. While the Mexican government was so powerful as to be able to impose rules on criminal organizations, then it was not really, it was an issue of law, but not an issue of affectation of the population. When these organizations became so powerful and the government became so weak that they could impose terms on the government, it's when it made crisis. I don't have an answer to your question. I think that there is, in itself, I don't think there's a contradiction, but I think your question summarizes the challenge that Mexico faces, and that is how to institutionalize a country, how to bring rules of the game that everybody can accept and live with, and a system of government that applies them fairly. And those are, that's an extremely tall order, no matter how you look at it.
Thank you very much. It was an excellent presentation, excellent discussion. One thing that came out in your discussion that I find interesting and troubling is that a lot of the idea that there will be a rule of law is based on the effects of the NAFTA agreement, which is a government-to-government agreement, which gives the people outside of Mexico a fairly strong bargaining position. In this case, we're talking about private investors from around the world dealing with a government. Is it really likely that the same pressures will exist in this situation as existed in NAFTA?
I think there are two different questions here. One question is whether energy will become part of the NAFTA procedures and panels and the like, which I believe is almost settled. The other question is what NAFTA brings to the table. NAFTA brings a mechanism for settling disputes among private parties, and that's what NAFTA. That's why investors in Mexico, foreign investors in Mexico, feel absolutely secure in their investments. In fact, if you look at for instance, if you compare the managerial teams that the big U.S. companies had in Mexico 30 years ago, and compare them to those of today, you'll be surprised to find that in the past they had quote-unquote politicians dealing with the government, people who would be looking after the interests of their companies in negotiations with the government. Today, the people in charge are undistinguishable from a plant in Houston or in Detroit. They are managers looking at issues of quality, production, efficiency, and so on. And the reason is they no longer are concerned about the questions of respect for their investments or protection of their investments. Those are issues that are settled, that are perfectly well established by the mechanisms created by NAFTA. There have been many panels under NAFTA, and none of them has produced more than, I mean, some parties have been affected, some parties have benefited as in any procedure, but the procedure exists and works. So the only question in energy is whether it's going to benefit from exactly the same procedures. And as I say, as far as I understand, that's the question that is almost settled.
And then over here. Yeah, Stephen.
Luis, I've been interested in following the discussions in Mexico regarding law enforcement in the states. If I'm not mistaken, in Mexico, just like in the United States, much criminal law enforcement takes place through police departments that are run by the cities. I read in Mexican newspaper there's something like close to 5,000 municipios in Mexico, each with its own police department. And that's the problem. That is to say, we have problems in local police departments in the United States that appear in the newspapers as well. So one of the solutions in Mexico is called mando único. There should be a uniformity, or let's say at the state level, in order to ensure better policing on the ground throughout the states. Could you make a comment about that, whether you think that's important to the question of rule of law?
Well, Mexico basically adopted in its first constitution the U.S. Structure of government, of federal government, except that it was imposed from above as opposed to being built from below. So many of the problems that Mexico has in law enforcement have to do with the maladjustment that this has historically created. When the federal government was very powerful and could impose its rule, the questions of security were basically dealt with vertically from above. As the federal government has weakened in the past 2 or 3 decades, the issues of security have become paramount. Of course, there are some municipios, some local governments that are big enough to be able to deal with the problems and should be able to do so. I mean, Mexico City or Guadalajara or Puebla should be able to deal with, or should deal with them. Many of them don't. But there are many of those other thousands of municipios that have neither the budget or the capacity to deal with the problems. So as you say, one of the solutions that has been proposed is the mando único. The problem is that the governors have become the key piece of Mexico's politics in the last 2 decades. They are the most powerful, totally unaccountable. Most of them are extremely corrupt, and most of them use their power to A, enrich themselves, B, build the possibility of becoming candidates for the presidency, and 3, to submit and subject the people in their states. There are a few enlightened governments, or there are a few states that have a strong enough civil society that hinders many of these ill practices. So my sense is that there are a few places in which mando único would work, but in the majority it would be simply further strengthening the rule of very corrupt governors. So it's a conundrum. I don't see it, and I think that the notion that is becoming mantra in Mexico, that there must be a constitutional amendment for this purpose, I think is totally rotten. I think that it should be a case-by-case basis. It's more the proposal is more the result of desperation than an actual strategy and actually well-thought principle. Not surprisingly, most of the states that work fairly well, like Aguascalientes, Querétaro, Nuevo León, more or less, Yucatan, they have a mix. Some of them have a centralized command, some of them don't. So I don't think there's one solution. I think that there has to be a combination of solutions. Meanwhile, there are cases like Veracruz, there are cases like Chihuahua, where the abuse is extraordinary by the governors. So granting them all the powers to rule the states would be even more corrupt.
One more question.
Thank you for your presentation. I do see, and I would like to go further and with Tony's comment about justice and about this incorporation of this concept and the concept of the rule of law. I don't see in the definitions this concept being incorporated. NAFTA and energy reform. I don't think they have taken into account what people need, and this is why NAFTA was successful to some extent, but not to another extent, and that's why we have lived the problems that we have lived in the past 20 years. The contradiction in the country itself, the economic contradiction, is something that we cannot forget, and I think that when we talk about the rule of law, we need to talk about justice and equality to some extent. So how would you resolve this contradiction, or how would you incorporate this concept of justice in your presentation of the rule of law?
Well, NAFTA had one objective only, and that was to promote and make it possible for investment and trade to materialize. And that it has done perfectly. Anything else is beyond its scope and its objectives. And of course, the basic issue of rule of law for Mexicans, I mean, I think that the basic question is, why not have a NAFTA for Mexicans that would bring about procedures, rules, justice, and the like? We don't have that. We don't have a mechanism for that. It doesn't exist. There's not even a recognition in the political arena of the importance of it. And I think that's the single most important question Mexico has before it. I couldn't agree more with you. But I think it has nothing to do with NAFTA. NAFTA was meant to fix one specific problem, and it did very well. It has nothing to do with the basic problem of Mexicans at large, which is how to deal with each other, how to benefit from society, how to have equal access to justice. These questions are the single most important, I mean, the important questions. I agree with you, totally. Thank you.